What'll it take? What'll it take for you to sit up and pay attention? You know there are important things going on in this world, and you're watching college football. You're thinking about that refrigerator you want to buy that crushes ice instead of just making cubes. What'll it take? Will it take a cute little talking dog? Fine, that's what we'll do. Well, here's the lowdown on what you need to know today. Waterboarding, which in all of its various forms holds constant the simulation of drowning, it qualifies under the legal definition of torture. It's specified in the U.S. Code. Google 18 U.S.C. 2340 and look for that phrase that says threat of imminent death. Waterboarding is a torture technique carried out by the Spanish Inquisition, carried out by the Khmer Rouge, carried out by the Burmese government in torturing protesters. How do we know it qualifies as a simulation of drowning? Well, that's been something that's been testified in multiple circumstances, most recently by Daniel Levin, the acting assistant attorney general under George W. Bush, who had it tried out on himself, and he told them that it qualified as simulated drowning. Of course, the Bush administration had him fired for saying that. Now, the United States has engaged in waterboarding. That makes this question germane. Even though the Congress has provided some kind of immunity to those who actually did the waterboarding, because it's also a crime to engage in a conspiracy to commit torture under 18 U.S.C. 2340. Word on the street is that the waterboarding was authorized by John Ashcroft, Condoleezza Rice, and President George W. Bush himself. Now, if the Attorney General is on the record stating that waterboarding qualifies under the legal definition of torture, then the investigation, the impeachment, and the arrest of executive branch officials like Ashcroft, Rice, and George W. Bush, those individuals involved in the conspiracy to commit torture, becomes not only clearly justified, but also imperative, because it's the Attorney General's responsibility to initiate such a course of investigation. Have I got your attention still? Can your human brain process this? Good. Now, confirmation hearings are next. They're what's happening now, and they're the only moment during which Congress can compel testimony on waterboarding by that nominee or withhold the power of the Attorney General's position from that person. After confirmation, the Attorney General can refuse to answer any question about waterboarding without any consequence whatsoever. The thing is that 3 times in a row, over the course of a week and a half, Attorney General nominee Michael Mukasey refused when he was specifically asked to state that waterboarding meets the legal definition of torture. He said he didn't know what waterboarding was, so people supplied him information about it, and still he refused to answer, again and again and again. Now you know and I know that Michael Mukasey wants to be Attorney General, and that George W. Bush wants Michael Mukasey to be Attorney General. So all that had to be done in order for Michael Mukasey to have his feet held to the fire and George W. Bush to have his feet held to the fire was for the 10 Senate Democrats holding the majority on the Senate Judiciary Committee to affirm that they would vote no on Mukasey without the appropriate statement by Mukasey on waterboarding. Well, guess what happened? Senator Dianne Feinstein of California and Senator Charles Schumer of New York made their way to the microphone on November 2nd, 2007 to announce that they would vote for Mukasey, regardless of his refusal to answer the questions of the Senate. Senators Feinstein and Schumer destroyed that moment of accountability for the Bush administration and for its criminal behavior. Senator Schumer and Senator Feinstein were not only weak on Mukasey and weak on Bush, they were weak on crime. They were weak on violent crime. They were weak on violent crime perpetuated by the state itself. Feinstein and Schumer have abandoned their commitment to the rule of law in the United States of America. Schumer and Feinstein have abandoned the nation to torture. They've been very, very bad dogs. Don't give them so much as a bone, and don't give them your vote. Woof!